Number 5, the agency must establish FMVE before negotiations with the owner. The establishment of FMVE. The agency is required to establish FMVE prior to the initiation of negotiations, and that's required by federal regulation and the Ohio Administrative Code. That means someone of authority from the agency must establish FMVE, and it cannot be delegated to a consultant. At ODOT, it's generally the district real estate administrator who establishes FMVE. The act of establishing FMVE occurs when the real estate administrator signs the RE22 that was recommended by the review appraiser. How this works for the value finding report is the reviewer recommends the value finding to be the basis for FMVE. This is done by the reviewer completing, signing, and sending the RE22 form to the district real estate administrator. The district real estate administrator then establishes FMVE by signing the RE22 form that was recommended by the review appraiser. The act of the district real estate administrator signing that RE22 establishes FMVE for the agency. 6, the negotiator prepares the negotiation package. So when FMVE is established, the negotiator can now make the offer of FMVE, which is the compensation estimate by the agency, to the property owner. Prior to this meeting, the negotiator reads the appraisal and the RE22 and prepares something called the NIAGFO. It's an acronym. It's Notice of Intent to Acquire and Good Faith Offer. Those are regulations right out of eminent domain code in the state of Ohio. Additionally, the negotiator prepares all other paperwork necessary for the offer, which can include preparing contracts and instrument, writing negotiator notes, gathering brochures, preparing the NIAGFO, preparing the offer letter, getting pertinent parts of the plans together, as well as a copy of the appraisal. The negotiator calls the owner and arranges a date and a time to present the offer. Next, Item 7, making the offer. Eminent domain regulation mandates that a copy of the appraisal is provided to the owner during the initial negotiation visit. That comes right out of eminent domain code, which is Ohio Revised Code 163.04. What that means is if the negotiator does not provide a copy of the appraisal to the owner, they do not have the right to appropriate the property. So anybody who prepares a value finding, be aware that that value finding will be given to the property owner. The negotiator then presents the offer, which is the NIAGFO, and reviews the plans and all the forms with the property owner. We'll explain the appraisal and the appraisal review to the owner. We'll answer any of the owner's questions, and if the owner doesn't accept the offer, they're provided more time to consider the offer. Counteroffers may occur, and eventually either an agreement is reached on price and terms or a negotiation impasse occurs. And when a negotiation impasse occurs, we move on to number 8, appropriation. If the owner and ODOT cannot reach agreement to convey the property rights needed for the project, ODOT exercises its right of eminent domain, and it takes the property. For vacant land, ODOT has the right of physical possession once FMVE is deposited into the court. The value finding appraisal report is now used by the Ohio Attorney General's office in the appropriation case. As the appropriation case advances, the property owner's legal counsel is going to be provided a copy of the value finding appraisal report. Now time for knowledge check 4.